studying, I said, why not? It's something, it's always good to participate in such activities. So I'm going to talk about canon law. Most of the times I've heard, because I've been asked, why are you studying canon law? People have a negative conception of canon law. So I'm here today to give a different side of it. In a bus crash, a student of philosophy, theology, and canon law all died and went to heaven. St. Peter speaks to them. He speaks to each of them. What did you do in your mortal life? I was a philosophy student. Welcome to heaven. Just go straight through the gates. Then he asked the second person, a theology student, what did you do when you were on earth? He said, I was a theology student. And he says, welcome, brother. Enter through the pearly doors. And you, finally, the third person. I was a canon law student at the famous St. Paul University Canon Law faculty. Fantastic. We are so glad you made it. So confetti falls from above, a loud, raucous giant band appears and starts playing celebratory music. So there's music. And Jesus himself comes out to personally greet the canon law student from St. Paul University. It is a scene of pure elation. The theology and philosophy students look back and say, we don't mean to be ungrateful with our eternal rewards at Peter, but why did the other two of us get such a perfunctory greeting, while the other canon law student got a whole party? St. Peter replies, oh no, you misunderstood. Of course, we are excited for you guys to be here, but more excited for the canon law student who spent all his time studying and preparing himself in the upbuilding of the church and for the salvation of souls. Most people think of canon lawyers as bespectacled, gray-haired monsignors who sit in dark paneled rooms and quote Latin verses from authors dead for hundreds of years. It may have been like that once, but today, canon lawyers quote rather a different figure. The term canon is derived from the Greek word canon, meaning a straight rod. With time, the term acquired the meaning of a rule in a moral sense. The term canon was used by Gratiano to denote ecclesiastical laws, and later by the decretists. The decretists were the commentators of the Gratian Decretum, commonly referred to ecclesiastical law as canon law. Also, the Council of Trent at the Vatican I, used the term canon to designate their dogmatic definitions. The Code of Canon Law restored the use of this term to denote disciplinary laws of the church. Our experiences with law may invoke in us different feelings and emotions when we read or hear the word law. When many people get the word law, they start shaking. They're not comfortable with the word. In some of us, the term may evoke a feeling of restriction, limitation, bondage, etc. Some of us may go to the extent of arguing literally with St. Paul. In the absence of law, sin was dead. Thus, identifying law with the cause of or occasion of sin. But as a matter of fact, good and just law is supposed to be life-enhancing. St. Thomas Aquinas defined law as ordinatio rationis ad bonum communes, qui curat communitatis habent promulgat, which means ordinance of reason promulgated by competent authority for the sake of the common good. From St. Thomas's definition of law, there are 4 points which I would like to clarify. I would like to do that in French, because French is a very romantic language. Une loi est ordonnance juste de la raison. Cela signifie d'une bonne loi. Cela signifie qu'une bonne loi doit être raisonnable. It must be reasonable. Il doit être un produit de délibération attentive et sérieux. It must be deliberative and serious. You don't just get up and put a law. There must be a process of deliberation. For example, la loi contre le conduit sous l'influence de l'alcool est basée sur les résultats concrets que la consommation de l'alcool provoque une perte de contrôle. For example, the law against alcohol, while driving. it is meant to protect the life. It's for the common good. Deuxièmement, une loi juste est correctement promulguée. It must be promulgated. I remember 2 days ago, I visited a friend and he told me, in this house we have a law. I said, when was it promulgated? I don't know about it. You have to inform. A law which is not promulgated has no value. So quand une école ou une organisation, par exemple, édicte de nouveaux ensembles de politique, ils fournissent souvent des étudiants avec guide pour eux de connaître. So there must be books given out, there must be a promulgation that is expressed, it must be expressed so that people can get it. Une loi juste doit être promulguée par l'autorité compétente. That's the third thing. It's not really about promulgating, but competent authority. It's not anybody who promulgates a law. Seules les personnes ayant l'autorité légitime ont le pouvoir de créer et de mettre en œuvre des lois pour leurs communautés respectives. So you must have legitimate authority to promulgate a law. And lastly, une loi juste doit être pour des raisons du bien commun. It must be for the common good. It's not about making life difficult for others. It's for the good of everybody. Cela signifie qu'une loi juste, tout d'abord, suppose la promotion et le respect de la dignité et de la liberté de chaque personne. The dignity and the liberty of each person. Deuxièmement, il convient de favoriser le bien-être et authentique développement social de la communauté. It must be for the good of the community. Lastly, it should promote true and lasting peace. Any law should promote true and lasting peace. Sigomnyani, who is a great canon lawyer, defines law as 1. E-use essentially consists in this. It is what is good or just. So a law must be good and just. What is commanded, namely lex. What is holy and pertaining to God. What is straight and not devious. Or finally, e-use is that which indicates and constitutes a rule of conduct. That is a rule of conduct, a way of behavior. Its meanings are many. For it portrays that the thing e-use has its origin in God, the eternal law, which alone is the source and right norm of action. Now, I would like to talk, after having given this brief introduction, I want to go into the purpose of law in general. Why do we have law? The purpose of law in general is to order the social relationship of the community so that the possibility for procuring the common good may be maximized. I remember when in Italy our professor Canon Law used to tell us, if you are living alone in your house, you don't need a law. But when you get a second person, there must be a law for order. Because if there's no law, you guys will always be quarreling. So law tries to bring order into the house. So it is a condition sine qua non for order. That is, it is indispensable. We need law in order to create order in society. Therefore, the reason for the law lies at the heart of the very community. Individuals are bound by the law of a particular community because the law, while directly geared to the good of that community, comprehends also the good of each and every member of that community. For example, the law saying that you should not drink alcohol while driving. It's for the good of everybody, but if you drink, you kill yourself and you kill another person. The limitation or restriction of personal freedom apparently in the law is intended to enhance the exercise of that freedom within the parameters of the common good. As a matter of fact, law by nature tends to maximize the participation by the individual member in the life and good of the community. So you participate. Even the restriction or limitation of personal freedom presumed in law is positive in its intent and effect. Thus, for example, a law prohibiting drivers under the influence of alcohol or drug, apparently restrictive in itself, it is restrictive. But it is intended to protect the life and welfare of the individual and the would-be victim of impaired driving. In recent years, there has been an intense questioning concerning the relevance of the positive ecclesiastical law. Many people have questioned, why should the church have laws? Why? If the church is a spiritual, if the church has a spiritual dimension, why should we have laws? That's a different school of thought that came up during the time, during recent times. Now, these people say that canon law, those against canon law, that these people who are against canon law, claim that the church is essentially a charismatic spiritual community built on the fundamental principles contained in the gospel and nourished by the word and the sacrament. So that's what they say. So the church should always be there for sacraments, ministry, and there's no need to have the law. That's what they say. According to them, such an organism does not need a complicated legal system to attain its goals. So they say the church does not need. The spirit is supposed, according to them, the spirit is supposed to guide and direct the desires and aspirations, and consequently the interpersonal behavior of the members of the community. Since all of them have the Holy Spirit, why should they have the law? That Holy Spirit should be able to guide, to direct them. There's no need to have 1,700 canons, 1,756 canons. So, such an argument seems simplistic as it focuses only on one aspect of the church. It's very simplistic because it focuses only on one aspect. They forget the fact that the church does not only have a spiritual aspect, it has a social dimension and a pastoral dimension. That is why law is needed for order. It is true that the church is essentially a communio, togetherness. But it should be remembered that a communio with a social dimension. That is why canon law comes in. There's a social dimension. Following centuries of increasing complexity in canon law, I would like to go now back to the history. How did this canon law come about? Following the centuries of increasing complexity in canon law, Pope Pius X decided in 1903 that canon law, which was then scattered throughout thousands of papal and diocesan decrees, decisions, and commentaries, should be simplified into a single authoritative code. So he said, why don't we bring all those decrees together? Pope Pius X. By 1917, the church first code of canon law was ready, the Pure Benedictine Code, famously called the 1917 Code, which was widely recognized as a major legal and pastoral accomplishment. Its 2,414 canons were enforced through the Second Vatican Council at 1962 to 1965, by which time, though, it was clear that the 1917 Code was in need of reform. Pope John the 23rd said the code should be reformed. It's in order to upgrade, in order to meet to the present demand of the church. So beginning in 1966, and utilizing canonical and theological experts from around the world, this major revision process was completed by late 1982. In January 1983, Pope John Paul II promulgated the 1,752 canons of the new Code of Canon Law, which took effect the following November. This revised code, known commonly as the 1983 Code, will likely remain the Church's basic canon law for many decades to come. Till today, we still use the 1983. The only official text of the 1983 Code is in Latin, but unofficial translations are readily available. Canon law, like every legal system, is concerned primarily with protecting the smooth order of the society that itself. That's the primary aim of canon law, to protect the smooth order of the society that itself. For the last canon is clear about it, for the salvation of souls. That is the aim of canon law, to save souls. In this case, the society known as the Catholic Church has a canon law which is out to save souls. It's not out to penalize people. Canon law touches, to one degree or another, practically every aspect of church life. It touches every aspect. Canon law operates in service to the church that has spiritual responsibilities and supernatural responsibilities too. But canon law itself, with some exceptions, continues to function primarily as an objective regulator of that ecclesiastical society. It is not a judge of the interior state of the souls of Christians. Canon law receives church teaching from the magisterium and adduces the rules. That is why canon law, the foundation of canon law is theology. You need theology to, if you don't have theology, how can you make a law? So it's from there, theology and canon law work together. So the magisterium, the canon lawyer reads the magisterium and then adduces rules, canons which protect that teaching in appropriate ways. For example, the liturgy. You are supposed to read Sacrosanctum Concilium, which is a document on the liturgy, to else than the book on sanctification. Even those in church's leadership, parish priests, diocesan bishops, members of the Roman Curia, are bound by canon law. It's for everybody. For those persons, high offices and good intentions are not sufficient basis for taking a given action. Their actions must be in conformity with the requirements of canon law. Under certain circumstances, the failure of such leaders to follow the requirements of canon law can render their actions illicit or invalid. Many times people say, what was all this about invalid and illicit? It's very important. For example, if the sacrament, it must be, there's an ordinary minister for the sacrament and an extraordinary minister. If you do not have that ability, as Canon 10 says, you must have the capacity. If you don't have the capacity to celebrate the sacrament, it is invalid. You must have that capacity, as Canon Law 10 says. So the actions must be in conformity with the requirements of canon law. If it's not in conformity, then it is invalid. Let me take a very clear example. The example of, let's say, George ordains a priest. I can't do that. It's invalid because I don't have that capacity to ordain. Lawyers, civil and canon, are trained to advise people about how to use their rights and to fulfill their obligations in accordance with law. So lawyers and all that. In conclusion, I would like to conclude by talking about the second part, which is the last part, the pastoral dimension. For example, the pastoral dimension deeply influences the process of enacting, interpreting, and applying laws with the notions of justice, equity, and mercy. As Pope John Paul II said, may all canonists persevere in the vital work that lies before them, as generous servants, ever willing to follow the Holy Spirit's lead, as faithful stewards, seeking to place their talents and gifts fully at the service of the Father's will. To work for the proper implementation of the code is to work for the upbuilding of the church itself. It is to work for the salvation of the world. It is to play an extraordinary constructive role in continuing the redemptive mission of Christ himself. Canon lawyers must be aware of their grave responsibility in the task of consolidating the life of the church at every level, according to the spirit of the gospel, overcoming uncertainties and banishing laxity in the observance of the discipline, that by reason of his ordination to the life and mission of the church is truly sacred and salvific. Thank you very much.
Thank you, George. Préférez-vous de recevoir des questions en français ou en anglais? D'accord. So I have time for two questions that are brief. Spare me the preambles, please. We'll start with Tom and Susan.
Yes, Tom. Thank you very much, George. You've got a lot of ways to redeeming your profession in my eyes. Which even until this morning, last night's presentation didn't help. I had always viewed canon law as the progeny of the scribes and Pharisees, so well denounced by Jesus in the gospel. And I really, of course, with St. Paul, the law is a tutor that brings us to faith in Christ. But you've done a really good job. You've actually really raised the bar. But I want to ask you one simple question. Canon law and history and canon law and culture. The way you presented it, it seems as if you're speaking of the church as a monocultural society. The church is made up of many cultures. And of course, law, the only reason for law, according to Thomas, is for the common good. But the laws of different cultures actually are empirically based upon their culture and society. And a certain deductivism from a central core or a certain classicalism can be very detrimental to the church, to faith in Christ, and to actually being docile with the Spirit as disciples of Christ. Can you comment on that, please?
Mm-hmm. Well, it's true that we have different cultures in the church, and if you read the code of canon law, there's always a liberty. The code says at the discretion of the bishop, the diocesan bishop of the area. It is a code for all Catholics, but then the diocesan bishop can make certain provisions depending on the culture of where he finds himself. Let's take the example. We have the Roman right to celebrate the Mass, but we have the Congolese right of celebrating the Mass too. So there's an opening, there's a possibility when a culture is a bit different. There's a possibility in the code where the diocesan bishop can, for example, the famous ministerial quaedam. Ministerial quaedam was a document on allowing the laity to be extraordinary ministers. So, but Pope Paul VI said, yes, there's a possibility to allow them, but there's a possibility to allow them, but then the diocesan bishop should forward it to Rome. There's always an opening. There's always an opening. Because not every culture will accept that. For example, the serving of mass by women. Some cultures, in my country where I am, some bishops, some ladies can't serve mass, while in some other dioceses, some ladies can't serve mass. So it depends on the culture. The culture influences very much. But Canon Law respects the culture, enculturation.
Sue?
Paul asked my question, but I have another one, George.
Okay. I know.
I don't know, we've had this conversation before a little bit. I know very little about canon law, and I certainly don't profess to be, well-read in it whatsoever. So my question is kind of reflects my naivety a little bit. When a law is going to be, say, for example, updated,
Yes.
or going to be completely new and introduced into the code of canon law, how does it reflect, in its drafting, how does it reflect the experiences, cultures, and diverse views of all of Christ's family?
It reflects very much because before a law is promulgated, the Holy Father consults the results at the Synod of Bishops, different Episcopal conferences are consulted, they are represented. It takes time for a law, there's a deliberation before a law is promulgated. So there's a consultation of all the ecclesiastical provinces of the world, which every country has.
Okay, so there's a consultative body there.
There is always a consultation body.
Okay, all right, thank you.
Yeah, you cannot just promulgate a law without consulting. You need to consult. It's a process.
Because that's sort of tied with Tom's question. You know, how does the code reconcile church tradition,
Yeah.
which is very, very strong in the Roman Catholic Church, with changing culture, and evolving culture,
Well,
particularly in terms of human rights, and I'm thinking specifically in terms of women's rights.
Okay. But in terms of women, I think Pope Francis was very clear about that. He said the women are even more than the apostles. You guys remember that? He said that.
Yeah.
So the Pope Francis is clear about it. Women have a great place in the church. They have a great place in the church.
But they don't make law.
They don't?
They don't make law.
No, they don't.
So the continuation of this issue and others again should happen over lunch. Breaking bread together is a key component of not only bridging divides between theologians and canon lawyers, but also in between cultures. So break bread with us later. For the moment, though, I want to welcome our third morning presenter, Robert Sykes, who's going to